You're listening to an African Elements top news story for June 11th, 2025. Please visit our website at africanelements.org for more daily news, civil rights enforcement, and our community by Darius Spearman. Recent executive orders are reshaping how civil rights are enforced in our country. These changes carry significant implications for communities of color, particularly African Americans, who have long relied on federal protections to combat discrimination. The actions taken, such as the dropping of a racial discrimination lawsuit against Sheets, signal a clear shift in federal policy. Furthermore, these directives tell agencies to stop prosecuting certain types of discrimination cases. It is important to understand what these changes mean for all of us. Ultimately, these shifts impact workplace equity and how individuals can seek justice. Federal authorities have moved to drop a racial discrimination lawsuit against Sheets. They cite a Trump executive order that halts disparate impact liability in civil rights enforcement. This is not an isolated incident. It reflects a broader strategy. The Equal Employment Opportunity Commission, or EEOC, filed a motion to dismiss the Sheets lawsuit. They explicitly linked this action to a Trump executive order. This order tells federal agencies to reduce the use of disparate impact liability. Disparate impact liability is a crucial tool. It means that policies, even if they appear neutral on the surface, can violate civil rights laws if they create artificial barriers that disadvantage different demographic groups. This concept has been a long-standing method for identifying and addressing discriminatory practices. The Trump administration's executive order is part of a larger plan to redefine civil rights enforcement. It aims to guide agencies like the EEOC to adopt policies that align with the administration's priorities. One key priority is stamping out diversity and inclusion practices. For instance, the April 23, 2025 executive order specifically instructs the EEOC and the Department of Justice, DOJ, to review and drop or revise pending cases that depend on disparate impact theory within 45 days. While the Supreme Court recognized disparate impact theory as a valid enforcement tool for the Civil Rights Act of 1964 back in the 1971 Griggs v. Duke Power case, federal agencies are now restricted from using this legal theory. However, private individuals can still bring claims using this theory unless the law changes or is fully overturned. On January 21, 2025, President Trump issued an executive order called Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This order specifically rescinded previous executive orders that supported equal employment opportunity and affirmative action connected to race and sex. These actions are part of a broader campaign. The executive order prohibits federal contractors from using race, color, sex, sexual preference, religion, or national origin for workforce balancing. It also prohibits them from maintaining DEI programs considered illegal. While existing prohibitions against discrimination, including those under Title VII, remain in place, affirmative action and DEI requirements for government contractors are eliminated under this new policy. This distinction is important. It means employers still cannot overtly discriminate, but they no longer face federal requirements to proactively ensure diversity or equity in their workforce. This shift could impact how federal contractors, which are businesses providing goods or services to the government, approach their hiring and workplace culture. The implications of these policy changes are profound for African American workers. Reduced federal enforcement of anti-discrimination protections makes it harder to challenge discrimination in the workplace. Moreover, it limits access to crucial resources and remedies for those who experience unfair treatment. This situation could lead to increased underreporting of discrimination. Workers might fear retaliation or feel that there is no meaningful external support for their claims. Furthermore, these shifts could mean fewer opportunities for advancement for Black workers. Historical patterns suggest that a weakening of civil rights enforcement disproportionately affects communities of color. Our community, which has fought for generations to secure workplace equity, could face new hurdles. Without federal agencies actively pursuing disparate impact cases, employers might unknowingly or even knowingly implement policies that create barriers for Black employees. This can impact everything from hiring and promotions to training and fair pay, potentially reversing progress made over decades. While the federal government's approach to civil rights enforcement is changing, it is important to remember that legal avenues often remain open for private individuals. For example, if the EEOC drops a case like the one against Sheets, a black worker still sought to continue the case independently. Private individuals retain the right to file disparate impact claims under Title VII. This means individuals can still pursue justice through private lawsuits. After the EEOC closes a discrimination complaint, they issue a Notice of Right to Sue. This allows the complainant to file a lawsuit in federal court within 90 days. Civil rights organizations and legal aid services are crucial in this landscape. They can provide support, advice, and representation to individuals pursuing claims where federal agencies may no longer step in. This shift places a greater burden on individual workers to pursue their rights, requiring resources and determination. The long-term policy goal appears to be a reduction of federal oversight in workplace discrimination, shifting the primary burden of enforcement to private litigation. This could fundamentally alter the landscape of employment law, leading to decreased accountability for discriminatory practices and increased reliance on individuals to fight for justice in the courts. Copyright African Elements.